Hi, I'm Susie, Program Specialist with the Sonoma County and Sonoma County Charter, SELPA, and I'd like to give you some information about your rights as a parent of a student with a disability in the IEP process. No matter if you are new or experienced with attending IEP meetings, you've probably seen this document. It's called Notice of Procedural Safeguards. It's about 13 pages long, which is pretty dense, and so I thought I'd take an opportunity to summarize this document and highlight some of the really important rights that you have as a parent of a student with special needs, as well as how to navigate if you have a question or concerns about your child's educational program. Let's dive into how we can find this document. So I'm going to take you to our home screen, which can be found at sonomaselpa.org. And from here, we can go to the Documents tab, and you can scroll down to Parents' Rights Documents. Click on that, and it'll take you to this other screen where we have the ADR brochure, information about our CAC, and also the Notice of Procedural Safeguards, both in English and in Spanish. Pretty easy to find. By law, under IDEA, you must be given this Notice of Procedural Safeguards at many points in the special education process. IDEA, or Individuals with Disabilities Education Act, requires public school districts to provide a free, appropriate public education to eligible students with disabilities. Basically, schools are supposed to provide educational programs that meet the specific educational needs of your child to enable them to be successful in their education. The Individualized Education Program, or IEP document, which is developed every year, documents the services, supports, and goals that the school will provide to your child. By law, if enrolled in a public school, these services are provided to your student free of charge. As a parent or guardian, you have the right to participate in any decisions about your child's special education program, including whether your student can be tested or qualify for special education, what your child's educational placement will be, and what services and supports your child will receive. You are a critical part of the IEP team, and your input and opinion matter. IEP meetings have to be arranged at a mutually convenient time, and you should have every opportunity to have your voice heard before, during, and after IEP meetings. If you need an interpreter, the school district must provide one. IEP meetings should be open discussions, and IEP teams make any decisions about your child's special education program in a collaborative way. If you have a concern or question about your child's education, we encourage you to contact your child's teacher or school administrator to discuss. In addition, if you have other questions, you may contact the Sonoma County Charter SELPA. Finally, in Sonoma County, we have Matrix Parent Center and Resource Center. It's a parent organization who can provide information and support to you in working with schools about your child's education. You can contact them at area code 415-884-3535. Let's talk about prior written notice. It basically means that a school district must tell you in writing when it is making or refusing a requested change in your child's special education program. In addition, school districts must tell you in writing when they wish to evaluate your child. Schools are required to get your permission before assessing your student for special education for the first time. In addition, schools are required to get your signature of agreement before moving forward with special education services. If you refuse to provide consent, in some circumstances, the district may file for a due process hearing, which means that a court will decide whether the plan can move forward. As a parent, you may revoke consent for special education services for your child. You must do so in writing. If so, the school will then send home a prior written notice explaining what will happen and then stop these services. If appropriate, students will be tested in all areas of suspected disability. Your child will be assessed in a non-discriminatory way and in the way that's most likely to be accurate. For example, if your child's native language is not English, they will be tested in their native language. If you disagree with the results of an assessment done by the school district, you may ask for an independent educational assessment to be paid for by the school district. The district will either agree to do that or they will file a legal action to show that their assessment was appropriate. IEP teams must consider any independent assessments. You have the right to review all of your child's educational records, and these records must be provided within 5 business days of your written request. If you disagree with the school district about identification, assessment, educational placement, or the special education program offered by the school district, you may file for a court hearing to resolve the dispute. You have 2 years from when you knew about, or should have known about, the school district action you disagree with to file a complaint for a due process hearing. Either you or the school district may ask to resolve the dispute through mediation or alternative dispute resolution, which attempts to come up with a solution that both you and the school district can accept. If your student has been removed from their educational setting for more than 10 days, such as for a suspension or expulsion, the school district must provide services to support your student and must hold an IEP team meeting to determine whether your student's conduct that resulted in the suspension or expulsion was caused by their disability. If this meeting finds that the conduct was not caused by the disability, it can go forward with the suspension or expulsion. But you have a right to a due process hearing that must occur within 20 days. Students enrolled in private schools but who qualify for special education may receive some limited special education services as determined by the local SELPA. Currently, the only services available for such students in Sonoma County are services for students with visual impairment or deaf and hard of hearing disabilities. However, the school district must offer a full special education program in their district should you decide to enroll your student in the school district. If you think your school district has violated federal or special education laws or regulations, you may file a complaint with the California Department of Education. Details about where to file are included in the Notice of Procedural Safeguards. If you need to obtain more information, you can contact the CDE Special Education Division Procedural Safeguards Referral Service at or by visiting the website. In addition, you can always contact us here at the SELPA. Our number is area code 707-524-2750. Thanks, and please let us know if you have any other questions.